Good afternoon, good evening, everyone. We have another edition of Live at 5 with Tim Panic Law, discussing the cross examination and the direct examination of Judson Welcher. This has been, as you can understand, um, a very interesting direct and cross examination because after all this time, we finally got into the nitty gritty details of the pedestrian strike. There's been a lot of talk about whether or not the Commonwealth was able to prove this um, fact that Officer John O'Keefe was struck by a vehicle. That's kind of what has been the argument from the defense and from people online from the case from the start. It's like you can't prove Officer O'Keefe was struck by a vehicle. That wasn't entirely true to begin with, even before the testimony, but now it's most definitely not true. So let's recap of what has been introduced. First, the meteorologist testified about the hard ground that what would be outside 34th Avenue. Remember, this is the end of January in the midst of a blizzard. Anybody who's lived in the Commonwealth of Massachusetts or in any state that sees snow knows how hard that ground is in January. That's very important. So you're thinking to yourself, it's like, okay, that's the first piece of it. Then Dr. Wolf testifies that John O'Keefe's injuries were caused from a fall to the ground, where he hit his head on the hard ground at a great speed. That's what he said. So that's very important to be able to discuss about that, because a hard ground is what's actually that fault on the hard ground is what caused it. In addition to, you have embedded pieces of microscopic pieces of the taillight embedded in Officer O'Keefe's clothing. As the analyst stated, the largest was the size of a piece of rice, and most were smaller. What we saw under this microscope was very clearly pieces of the taillight. So that's where we're at before going into, and then in addition, there's the hair on the taillight, DNA on the bumper. Individually, it's not enough, but you put it all together. Now you have Dr. Welcher's testimony that the injuries sustained by Officer O'Keefe were consistent with a pedestrian strike. And there you have it. That's the testimony that you can be able to now. It has been proven that a pedestrian strike took place. Cross-examination is not over. But that's where it is on direct. It's that there is enough evidence now for a pedestrian strike, and now more so, which we didn't have in the first case. They did not explain the backwards reverse to a point that a murder 2 charge would be sustained. And after hearing the evidence, now you have that the vehicle reversed at 24 miles an hour. I think it was like something like 53 feet or whatever it was. And the RPMs reached 3,500. So people were saying it's like, oh, well, the vehicle was in snow and it got stuck. Shut up. That's not what actually happened. What happened was based on the reconstruction, the defendant drove the vehicle, put the vehicle in reverse at a high rate of speed. To be able to get to 3,500 RPMs that quickly, that is somebody who is showing intent. You remember, the Commonwealth doesn't have to prove intent to murder. They just have to prove intent to commit serious bodily injury. And knowing that could lead to serious bodily injury and backing up the vehicle like it did at that high rate of a speed. And remember, as the defendant stated, the data is what the data is. So it's definitely an interesting situation. Excuse me. My daughter's in daycare, and you always when your children go to daycare, you're going to get sick with them. So just know that if you don't already. What's very important about this is now there is enough. Now the jury's paying attention, because what I've said previously in previous episodes, when you are considering evidence in a murder case, you need to be able and look over to that individual sitting at the defense chair and say to yourself, is this person capable of murder? Not at first whether they proved it, is that person capable of it? And think of what the evidence has been presented. There is the evidence of the Aruba trip where the defendant thought she was cheating on the alleged victim was cheating on the defendant. Add that to the voicemails where the defendant was calling Officer O'Keefe a fucking pervert, and that he's banging some other girl. In addition to what is being alleged, and that they were always fighting. Officer O'Keefe stated that they believed their relationship had run its course based on testimony we heard. So you put all of that together. Now it's like, all right, the defendant's saying it's like, there's only going to be one person who's going to go down, Jim McCabe. It's either going to be you or it's going to be me. So when you hear that, as I've stated before, the defendant should have never said anything whatsoever until she was acquitted, free and clear. And then she could say whatever she wanted. She could confess to the crime for all that mattered. It wouldn't help her civil suit where she would be found liable, but she could never be touched again for criminal charges. But that's not what happened. Hung jury is not an acquittal. And the act of basically saying all these things, like, could I have clipped him? Could I have? I hit him. Not good. So that's where we're at when we come to Dr. Judson Welcher. This guy is a doctor who's been experienced for I don't know how many years, something like 31. He's 31 years, something like that. I think he got his PhD 2004, 2005. So let's say probably 20 years. So he wasn't going to, as we know, going to get impeached with his LinkedIn profile and all the other eye-rolling stuff that we saw last week that didn't really land anything, because it's like, you're not challenging the findings. Like, this is forensic data. It's like all he's doing is interpreting it. And that's kind of what Dr. Welcher has done with this case, is just interpreted the findings. And it's like, this is what the black box of our car. What we know from the first trial, that eventually the jury, Hank Brennan's going to cross ARCA with this. Like, didn't you previously state that the black box data wouldn't provide anything of any value? That's coming. That is. And when he says, yeah, it is, it's like, all right, then why does it have how the speed was, how fast the RPMs were going, the direction, the GPS? Not important. Yeah. They're gonna, that's gonna be almost like the torture scene in Braveheart. At the end of it, it's just watching that cross-examination, like, Jesus. It's like there's just nothing going to be left of ARC after that. Excuse me. So when you think about what is going on during that direct examination, you need to get into about, all right, what caused the abrasions on the arm? You need to be able to talk about how it's consistent with pedestrian strike, because you know what the defense is going to argue, that it was an animal attack. He was beat inside 34 Fairview, and Chloe the dog came and bit him. But with this testimony, then it's like you have an expert in accident reconstruction versus a lady saying it was an animal attack. It's like, well, was there dog DNA? No. So what are you basing it on? A photograph? That's not going to hold up particularly well when it comes to that point. But so when you think of what the defense has done, so for the most part, Attorney Alassi has done a pretty good job. But with Dr. Welcher, here's the reality: this cross-examination has been awful. It has not been effective. I had to turn it off. I'm like, well, I had court. I had a case motion in limine. Thankfully, that was granted on my client's behalf, which should result in the case being dismissed. So, but I couldn't listen anymore. I'm like, are we coming to a point? Are we going to challenge the findings? Are we going to talk about, no, we're still arguing semantics. Got it. Yeah, I got something else to do. And that's what we mostly saw today. It was just arguing. And it's just like, what do you want to ask next? What's my favorite color? Or it's like, are we clear? Crystal, like something straight out of A Few Good Men. That's just like what was being argued today, instead of like actual facts and like, all right, well, what about this finding? How is it inconsistent with? It just wasn't happening. And then at the end, it's like, oh, well, I'm halfway through. Halfway? He was being crossed for like 4 hours, and you're only halfway through and you haven't even made a point. And that's really tough for me while listening to that. It's just like, um, I know it's like it's tough being dealt a bad hand. It's like, yeah, you're trying to be able to do that and make up for the defendant basically saying outside the data is the data. And now you can't even argue it because you know that's going to be played probably at the end of this witness, if I'm guessing. If not during probably in a rebuttal case. Because it's just like you're conceding what it's saying is true. You need to be able to keep it open that when your experts testify that their data is going to be different and show something different conclusions. And they're talking about, oh, well, look at how much money they were paid. I was like you're just opening yourself up to the same attacks that the Commonwealth is going to cross-examine you with. So it definitely is, you're opening a can of worms. You can't really figure out one way or another what actually makes sense, what you're trying to elicit. Because if you don't have a plan on cross-examination, and I said this on Twitter, 3 things you cannot do. 1, you cannot allow to ask questions you don't know the answers to. Why? Because you need to control cross-examination. And if you're asking questions and it's just like, well, now we're going a different rabbit hole. Now I need to ask this question. Now you have to ask 20 questions you weren't planning on asking that didn't even get you to the result, didn't elicit a fact you needed. It just got you back to where you were thinking. Think a linear timeline and think that you asked a question you didn't know the answer to, and it takes it down. Now we're in like Back to the Future territory in the alternative 1985. But you've taken asked a lot of questions that have no bearing on what you were trying to prove, but you have to ask the questions to get it back to where you need the case to be. And the second thing, you cannot allow the individual to control cross-examination. That's what happened today. Is Dr. Welcher was controlling the cross-examination. He was basically being able to say what he wanted to say. And the last thing is you need to make sure that witness, you're asking leading questions. So you want the answer to be yes or no or correct. That's what you want. You don't want these long, convoluted answers. This is not a situation where the witness is going to hang themselves with their testimony. They're just going to continue to say more things that you didn't anticipate them saying. And you may open a door that they would not otherwise be able to enter. Very simple stuff. When thinking about how the best way to save this cross-examination, you got to just argue the findings. Questions about the findings. Isn't this true? Isn't this not standard? Is that not common practice? Being able to poke holes. That's where that cross-examination would be, not arguing semantics. So when you're asking a question, isn't it true? Like, because unfortunately, a lot of the attorneys, especially ADA Brennan as well, Alan Jackson, are not used to doing direct examination. So a lot of the questions it would be objected to leading, they're on direct. It's if somebody's on direct examination, their question shouldn't be ending with correct. That's cross. David Yannetti kind of does cross correctly because it's a leading question that locks the individual into a yes or no or correct answer. That's what you're looking for. What do I think about Special ADA Brennan's direct? I definitely think it was pretty devastating. It's being able to close all the, fill all the gaps that people were complaining about, explain what the pedestrian strike was, and get the single most important piece of testimony. John O'Keefe's injuries were consistent with the pedestrian strike. That is the most important piece of evidence. Now you've tied all the other circumstantial evidence together with expert testimony. And the jury hears the 24 miles an hour. So now now you can sustain a murder conviction on appeal on those facts. Obviously, if the defendant is convicted, it'll be appealed all the way up to The Hague, depending on what kind of mood her attorneys are in. So what is interesting about this case, what's happening this week is the Commonwealth will be resting. And they use the strategy of rest with your best witness. So the testimony they're getting is the most important of all. Everything else was important. Everything else led to this point, because you need to be able to prove his injuries are consistent with a pedestrian strike. People are like, well, the ME says, like, no, the ME said the injuries to the lower extremities were not consistent with a pedestrian strike. But Dr. Welcher testifies, like, you're not always going to find broken bones. You're not always going to find bruises in these types of situations. And that's important because the medical examiner doesn't do accident reconstruction. She deals with what caused somebody's death and what the injuries they sustained. Dr. Wolf testified about how this individual would have sustained these injuries. So you have the meteorologist provided the where, the hard ground. Dr. Wolf provided the why, the how. It's like what actually caused them and what actually caused his death. And Dr. Welcher provided the how. How did the decedent sustain these injuries? All of that put together. That is how you prove a case. And that's what didn't happen in the first trial. Trooper Paul was explaining it, and I was like, I knew what he was trying to say, but I was like, this is not enough. What you're providing is not going to sustain a murder conviction. And even if she were convicted in the first trial, I think the appellate court would have overturned that conviction. I definitely think that what is most important going forward is preparing for the defense case, what is it going to be? They listed 100 people. They're not calling 100 people. It sounded like their case was going to take 2 weeks. You can't call 100 people in 2 weeks, realistically. So what is the defense strategy from here? There's one in two ways. You can go third-party culprit. It's weak. It really is. You can't argue Colin Albert, so all you can do is Brian Albert and Brian Higgins. Jury's not going to buy it. But you got to argue your facts. You got to play the hand that you're dealt. That's how it works. Or you take your chances and you put it with battle of the experts. And when I say a battle of the experts, it's a situation where you're saying it's like, our expert is right, your expert is wrong. No collision, here's why. The problem with this time around is that the ARCA is going to get hammered. They're going to get hammered for their independence that they alleged with the brought in to testify that the feds retained us. It's like, and then there are emails between the two of them, between Alan Jackson and ARCA, where they're coordinating his testimony for the federal investigation. Not really independent. And that's going to come out. So from there, it's how much more is the defendant going to say, make more statements. I don't know if the defendant should decline comment. I've said this from the beginning. There's no upside in talking to the press. The press is not going to acquit you. The jurors are on they're on sequestration. They can't watch the news. They can't read the newspapers. Anything you're saying to them, who are you trying to convince? Nobody. The fact finders are going on deaf ears. So that's just, then it's like, oh, I want to control the narrative. To whom? To whom? If you get convicted, it's for 12 people who didn't watch all of your outside the courtroom theatrics. It's simply trials are won and lost inside courtrooms. Very simple. They're not won and lost on the deep, dark parts of the internet. They're not won by bloggers and content creators. They are won by facts and evidence. And that's what's so important understanding about this case, is that when the facts were actually presented the way they should have been, it's a much stronger case. Some of you knew I actually acquitted the defendant last year because the murder too wasn't proven beyond a reasonable doubt. So you have to say to yourself, it's like, what is the defense planning on doing? They're going to call Lucky again and say that they didn't see anybody on the lawn. Well, somebody stated they saw a big black blob on the lawn. So it's not going to work. The grass is definitely something that's going to play for the Commonwealth. So I have to think, based on what Alan Jackson said, there was no collision. There was no collision. they're going ARCA, option B. I think I think third party culprit looks way too desperate, and if they did that, jury's gonna be like, no. So I think that's all I got for today. So what I probably do another show tomorrow night because I want to talk about finish the cross examination. But for now, thank you all for tuning in, and I'll see you all tomorrow. Thank you.